Hello, my name's Leja. I'm a real-life lawyer, and I'm on a mission to demystify the law and how it affects your everyday life. Part of your everyday life is probably watching movies. I do too. Let's talk about one, and I mean Hamilton, the musical. Now, I used to be pretty into musicals. I had my theater nerd moments. Yikes. But I'm not like super into musicals now. However, there is just something about Hamilton that I think gets people going, even if they're not huge theater nerds. It's just, you can't argue when something's just good, okay? And if you don't like Hamilton, well, see you later, because this certainly ain't for you, but please subscribe before you go. So obviously you probably know Hamilton is the wildly popular musical that has taken the world by storm. It's a hip-hop opera about Alexander Hamilton, one of our founding fathers. It takes place during the founding of our nation, including the Revolutionary War and the creation of our country. And also it's filled with talented people and actors and singing and dancing and so many words in every song, and it's a whole heap of fun. So let's get started. Actually, before we get started, I'd like to ask you to please give a thumbs up to this video if you find it interesting or entertaining, and please hit subscribe if you'd like to see more from me. Okay, let's do it. Like, first of all, great, it's amazing, but like, what a testament to following your dreams, because like Lin-Manuel Miranda had to go around probably for years while creating Hamilton, and when people asked him like, oh Lin, what are you working on? He had to be like, I'm writing a hip-hop opera about Alexander Hamilton and the founding of our nation, and people probably were like, oh, okay. So, you know, don't give up on your dreams. Hey, now you're making me mad. God bless him for sticking to that role with, man, so much spit.
Is it a question of if or which one? Hey.
Okay, honestly, literally, if I was sitting in the front row of that and Lin-Manuel Miranda like winked in my direction and said, hey, I'd be blushing. This might be the number in this thing that gives me the most like feels. Stay alive. This song also really gets me. Aaron Burr as a character is not likable at all, but these numbers that he gets throughout this show are just moving. It's almost like he's a complex character or something. Afterbirth of a nation.
My client needs a strong defense. You're the solution.
Who's your client?
The new U.S. Constitution.
No.
Hear me out.
No way.
A series of essays anonymously published defending the document to the public.
No one will read it.
I disagree.
And if it fails?
That's why we need it.
Okay, so let's talk about federalism and the Federalist Papers. Hamilton was a founding member of the Federalist Party in the United States. But what does that even mean? So federalism is basically a system of government where there are separation of powers between the head centralized government and the subdivisions of government. So that means there are two levels of government in federalism, and the powers to govern the citizens are divided between them. In federalism, both levels of government have the power to create laws, and each level of government has specific powers reserved for each specific level of government. And both levels have a certain amount of autonomy from each other. Federalism is embodied in the US Constitution in many different ways. First, you have the Supremacy Clause in Article 6. And let me just read to you what the Supremacy Clause is, because I feel like in school, like, we don't even read the Constitution. I didn't read the Constitution in full until I went to law school, and I think that's actually a really big shame that so many people who live in this country have never actually read the Constitution front to back. It's not a long document. I highly suggest just Googling it and giving it a read. But let me at least read for you what the Supremacy Clause says. So again, this is Article 6 of the Constitution, and it says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So what this means is that the federal laws that are created under the Constitution and by treaties and by the creation of laws at the federal level reign supreme over the laws created at the state level and by state constitutions. So if there's a federal law that conflicts with state law, the federal law will preempt the state law, meaning the federal law will be the governing law and the state law will not be able to overrule the federal law. Okay, and then related to federalism, Article 1, Section 8 lists out the powers that the federal government has. So yes, you have the supremacy clause under the Constitution, which says that federal law preempts state law. However, the Constitution also limits the federal power by enumerating or listing the specific powers that are given to the federal government and reserving all non-enumerated powers or things not listed in the Constitution to be within the purview of the states. Again, if you think about the context of when the Constitution was written, America had just fought a revolutionary war against Britain specifically because of the issue of power being concentrated in one head of state and power not being given to the people. So federalism, especially as it's embodied in the Constitution, is meant to ensure that a singular head of state or a centralized power does not have too much control over the will of the people. So in order to do this, the Constitution adopts federalism, where the federal centralized government has some powers and has its own sovereignty. However, those powers are limited and specific, and everything else goes to the states under the assumption that state control is going to at least be able to better reflect the will of the people in each separate state based on that state's needs. So Article 1, Section 8 gives specific powers to the federal government, and those powers include the powers to tax and spend and the powers to control interstate commerce, which are probably the two most cited powers that Congress uses to enact its laws. So then in the Bill of Rights, we have the 10th Amendment. And the 10th Amendment does what I was just talking about. It reserves the powers that aren't enumerated in the Constitution for the states. So any power that isn't given specifically to the federal government is reserved for the states. And those powers include creating school systems, creating public safety systems, overseeing state courts, managing travel and infrastructure within the states. These powers are what's called reserved powers because they're reserved for the states, and the federal government can't really infringe on a state's power to govern in these areas. And then you also have concurrent powers, which means that both the federal government and the state government equally have powers to do certain things. Those include taxing, building roads, and creating lower courts. That's why we have both a system of federal courts and a system of state courts. So what Alexander Hamilton is talking about here regarding the Federalist Papers were a series of essays that defended this new Constitution. They were called the Federalist Papers because that's what the Constitution embodied. It was federalism. It was the ultimate idea of the people being able to govern themselves free from too much centralized power. And again, when I'm saying too much centralized power, I don't mean it in the kind of Democratic versus Republican sense that kind of overrides political discussions today. That is that Republicans tend to want more power in the states and a less centralized government, and Democrats tend to be okay with a stronger central government. This was a lot more stark back then. We're talking the difference between people being able to vote and to be taxed based on their votes and people being ruled by a monarch. I'm not saying that if you're pro-federalism that necessarily means that you are a Republican. I'm just saying that it means that you don't necessarily want to be ruled by a monarch, at least in the context of federalism in the founding of America. So the Federalist Papers were Alexander Hamilton's attempt to convince the states to ratify the Constitution. There was a whole ratification process after the Constitution was written, and it had to be ratified in order to become the Constitution of the United States of America. And so he wrote these papers in an effort to convince the populace to ratify the Constitution, and they eventually did, and the Federalist Papers did play a huge role in that ratification, and they formed the basis of a lot of judicial interpretation of the Constitution in the centuries since those Federalist Papers were written. It's firsthand documentation of how some of our founding fathers thought about the law and about the Constitution and how they interpreted different powers within the Constitution, how they thought about federalism, about judicial review, about checks and balances, and about a lot of the tenets that form the basis of our thinking about the Constitution and the underpinnings of our country today. The Federalist Papers are still often cited both in scholarly articles as well as in judicial opinions because they're so useful in helping to interpret ways in which certain people who helped to form our Constitution thought about very important issues that we still discuss and have to interpret today. Pretty cool, right? Okay.
If we assume the debts the union gets, a new line of credit, a financial diuretic, how do you not get it? If we're aggressive and competitive, the union gets a boost, you'd rather give it a sedative?
So at this point, Alexander Hamilton is arguing with Thomas Jefferson and James Madison about whether the federal central government should assume the debts that the states took on during the Revolutionary War. States like Virginia, southern states, had paid off their debts, but northern states had not. As noted in this argument, a lot of the reason why southern states were able to pay off their debts more easily is because they were able to profit off of slave labor, off of free labor. So yeah, it was easier for them to make money and pay their debts back after the Revolutionary War. And as we'll see later in the musical, and is accurately portrayed, Hamilton, Madison, and Jefferson came to an agreement called the Funding Act of 1790, where Jefferson and Madison agreed to vote to allow the bonds or the debts owed by states after the Revolutionary War to be paid or to be assumed by the federal government, and in exchange, the head of the federal government would be in Washington, D.C., which was part of the South. So basically the way that it worked was in order to assume the debts and pay them back after the Revolutionary War, the federal government would issue bonds, which was basically a way to obtain a loan from rich people. The rich person would buy a bond, and that money would go to the U.S. government, and in exchange, the U.S. government would pay interest on that bond. This also meant that the rich had a tangible stake in the success of the United States government, because the more people who bought the bonds, the better the credit of the new republic. And despite this whole argument that you see played out here in Hamilton the musical, that I'm sure is honestly is very close to real life, Jefferson, when he became president, continued this trend of having the federal government assume state debts and continued this system of selling bonds in order to pay off debts at the federal level. Because of this bond system, the U.S. was able to solidify its credit at home and abroad, and this good credit went on to facilitate for Thomas Jefferson, when he was president, the Louisiana Purchase in 1803. It also allowed the United States to borrow money in order to finance the War of 1812. So this agreement that's outlined in Hamilton the Musical is actually the impetus to a lot of changes that led to the creation of the United States as we know it today. For better or for worse. I mean, I could do a whole video about the ethics of the Louisiana Purchase and the War of 1812, but the mere fact of this accord led to the creation of the United States as we know it today.
Lord, show me how to say no to this. I don't know how to say no to this, but my God, she looks so helpless, and her body's saying hell yes. Lord, show me how to say no.
Yikes. All right. Let's talk about adultery. So these days, adultery isn't really prosecuted as a crime anymore, except for in very few states. But there are a lot of states that still have adultery statutes on the books that do consider adultery a crime. And not long ago, it was a regularly punished offense. However, the history of it is pretty sexist, and a lot of it is based kind of on the idea of the woman as a man's property. So let's look a little bit at adultery in early American law. So one of my favorite facts is that adultery can be traced back to a tort. A tort is a type of personal injury. It's civil, it's not criminal, so you wouldn't be criminally prosecuted for a tort. You could be sued in court by someone, another person, for committing a tort against them. And torts are still, there's all sorts of torts. There's negligence and medical malpractice is a type of tort. But there was a tort in early English common law that then came over to the United States through, colonization, there was a tort called criminal conversation, which basically, conversation was a euphemism for sex back then. In criminal conversation tort claims, a man would sue another man for basically soiling his wife and would be able to receive compensation for basically the loss in value that he experienced due to the other man fornicating with his wife. So this idea of criminal conversation has been abolished in almost all states, but it's still recognized in North Carolina. Outside of the criminal conversation tort, there was also just the idea that fornicating with someone's wife was akin to theft, again, because women are property. But there were actually harsher penalties against women for adultery than against men for committing adultery, at least when it came to the criminal context. Again, because women are property, they need to stay in line, and if they don't stay in line, then they need to be punished more than a man, such that criminal penalties were a bit less common against men. Though again, things like the tort of criminal conversation was still something that a man could bring against another man to be compensated for the use of his wife, basically. There's also a tort called the alienation of affection, where one spouse could sue the third party for taking away the affection of the other spouse. Again, in the context of early America, this was almost always in the context of a man suing another man for the alienation of affection of his wife. This is largely, again, because women are property and because women couldn't contract back then. So being able to hire an attorney and sue someone, it just was kind of out of the realm of possibility for most women who didn't have their own money and their own ability to hire an attorney. So criminal adultery statutes, like I said, are still on the books in a lot of states, though they are rarely, if ever, enforced. A lot of them take a similar form to my home state of Minnesota's adultery law, which is still on the books, and I'll read it to you. They weren't even subtle when writing these laws about the fact that the adultery laws were very specifically meant to keep women in their place because they were property. So the Minnesota adultery law states that when a married woman has sexual intercourse with a man other than her husband, whether married or not, both are guilty of adultery and may be sentenced to imprisonment for not more than 1 year or to payment of a fine of not more than $3,000 or both. So it says that both are guilty of adultery, the man and the woman, but it only explicitly mentions the woman. When a woman has intercourse with a man to whom she's not married, then both of them are guilty. So again, it's the idea of the woman is the sinner in this situation, and the man is also guilty because he stole this property, is what is being insinuated by these laws. What's even more absurd is that within the statute, there's also a defense that is listed, an available defense that someone who's accused of this crime can use to defend himself against prosecution. And it says, it is a defense to violation of this section if the marital status of the woman was not known to the defendant at the time of the act of adultery. So if a woman is accused of this crime of adultery, she doesn't have a defense, but the man who's accused of committing adultery with a woman has the defense if he didn't know that she was married. So again, it's just reiterating the fact that women are property, because it's like, well, I didn't know she was someone else's property. And then the court's like, oh, okay, you're fine. But this woman, we're still going to prosecute her. She doesn't have any defense. It's wild that these laws are still on the books. And I know that they're not being enforced, but the fact that they exist is fascinating. I mean, look it up for your state. Google, your state plus adultery laws and just see what pops up, because it's unbelievable. So a lot of these laws haven't been enforced since the 60s. So basically what's happening in Hamilton, when the husband of the woman that he's having an affair with writes him a letter and says, I hear that you're having sex with my wife, pay me money and I won't tell your wife about it, that's a settlement offer. Because at this time, he could have taken Hamilton to court for criminal conversation or alienation of affection and been made whole by receiving some sort of compensation from Hamilton to make up for the soiling of his wife. And instead he just writes him a letter in this situation and says, look, pay me this money and I won't tell anyone. It's a settlement offer. It's an out-of-court settlement offer. Sorry, that one got me riled up, but that's the history of adultery in the United States of America. Let's keep going.
As far as the people are concerned, you have to serve. You could continue to serve. No, one last time. The people will hear from me one last time. And if we get get this right. We're gonna teach them how to say goodbye.
Okay, so it's true that George Washington did serve only 2 terms as president, but under the US Constitution, he could have served as many as he wanted. That's right, the Constitution as originally written did not have any term limitations for presidents. Washington only served 2 terms because that's how many terms he felt he was needed, and he didn't feel he was needed for a 3rd term in this new republic. And then after him, Thomas Jefferson, the 2nd president, only served 2 terms because he believed that's how many terms a person should get. And because the first 2 presidents only served 2 terms, that kind of just became the norm for like 150 years, even though there was no rule that restrained anyone from serving as president for more than 2 terms. So it wasn't until FDR that a president served more than 2 terms. FDR was president through the Great Depression, and a lot of the turmoils that he presided over and how successful he was at that time running the country despite all of these huge upheavals meant that it kind of made sense why the country voted him in. But he served 4 terms or 12 years as president before he died. He won the elections of 1932, 1936, 1940, and 1944. And he died just a few months after his final inauguration. So after this, it became apparent that maybe having a president who served that many terms kind of went against the underlying ethos of the United States Constitution, which was that we didn't want a monarch. So that led to the passage of the 22nd Amendment. The 22nd Amendment was ratified in 1951, and it states that presidents can serve for a total of 10 years, which means that, say, your vice president and the president in office dies, and you serve the last 2 years of that president's term, you can still get reelected 2 more times to equal 10 years total. And that's exactly what happened with Lyndon B. Johnson, because he became president after JFK was assassinated and then went on to win 2 elections. So this is a really accurate depiction. I mean, minus Hamilton and Washington probably weren't singing to each other about it, but it is accurate that Washington made the choice to step down as president, even though he didn't have to. And for 150 years, other presidents just kind of followed suit.
Look him in the eyes, aim no higher. Summon all the courage you require. Then count 1, 2, 3, 4, 5, 6, 7, 8, 9, number 10.
Okay, so that brings us to the final topic I would love to discuss in this Hamilton reaction video, and that is duel law. No, not dual law, duel law. You know, like the law of duels. It's a thing. So, a brief history of duels. Duels were popular beginning in the Middle Ages in Europe, and even though heads of state and the Catholic Church banned duels, people still did them. By people, I mean men. It was also known as judicial combat, basically a way to settle a dispute outside of a court, and God would determine who won based on who was right. So the person that lived, God decided got to win. So in 1777 is the first kind of recording of an actual code of duels. It wasn't a law, it was just written down, these 26 formalities that duels had to follow. These rules included the time of day that a duel should happen, the number of shots or wounds that a person would have to have in order to be determined the loser. That was kind of the duel code up until the 1830s when a South Carolina governor rewrote duel law. But again, it wasn't codified into law. It wasn't enacted as a statute. It was just a written code that was supposed to be followed when participating in a duel. Basically, the way that it worked is that each party had a representative. Those representatives would come together and they would talk and try to reconcile the issue. If the accused party, the one who had been challenged to a duel, apologizes, really if either party apologized, it would end, there would be no duel. And parties had the ability to apologize at any point leading up to the duel. Duels were often fought between aristocratic men. This was not kind of what peasants did. This was what elites did to try to settle disputes. And part of the reason for this was because it was tied to honor. So if you had honor, you would participate in the duel or you would apologize. And participating in duels kind of established that you were a gentleman. And they were often fought between men who were in the public eye and whose social status was often in flux or in question. And this meant that a lot of the people who fought in duels were journalists and lawyers. So the first recorded duel in US history happened in 1621 between a couple settlers. That is the year after the Pilgrims arrived on Plymouth Rock, so it did not take long for duels to become a thing here. Your chance of dying in a duel was pretty slim. Again, like is said in the musical, a lot of times they were settled before any shots were fired, and even if shots were fired, I mean, they're shooting with these old-timey guns. Your accuracy was really bad because you had to point and shoot quickly. It was considered bad form and ungentlemanly to take more than 3 seconds to aim after you both turned to fire. So often things would misfire, the accuracy was really off, so your chance of dying in a duel was actually pretty slim. So it's, I think, just really bad luck that both Alexander Hamilton and his son Philip died in duels. Duels were commonly accepted, even though they were condemned by heads of state and outlawed in most, if not all, states. They still were a commonly accepted form of adjudicating issues. However, people like Benjamin Franklin and George Washington both condemned duels, which you actually see in Hamilton the musical. So under the common law, and common law is judge-made law, meaning cases that are decided by judges are then relied upon later by judges, so it becomes kind of an established precedent. In the common law, killing someone in the course of a duel was punishable. However, because the people who were fighting duels were aristocrats, were elites, they often went without punishment because, like, I don't know, look around. So despite how commonly duels happened and how infrequently they were prosecuted, lawmakers nevertheless tried to pass laws in order to prohibit duels and make their occurrence less frequent. However, they often weren't successful. A lot of these laws were aimed at trying to disconnect the relationship between honor and dueling. They were trying to say that when you duel, that does not make you an honorable man. So the laws were written so that people who died in duels would be treated like someone who committed suicide, which was very frowned upon in a Christian society at that point. And people who committed suicide were buried with a stake through their heart. And so these laws were passed so that the people who died in duel would be buried in an unmarked grave with a stake through their heart, just like someone who committed suicide would be. Again, these laws did nothing to dissuade people from fighting in duels and were very rarely, if ever, actually enforced. Despite the creation of these anti-duel laws, people were still doing duels left and right, and they really weren't enforced because it was just social custom at the time. This popularity of duels rose pretty dramatically in the late 1700s in the United States, and that's due partially to an influx of Scotch-Irish immigrants who apparently were kind of rough and tumble, and duels were really frequent. But it also is because the late 1700s is when the Revolutionary War happened. This war happened because there was unrest, because courts weren't functioning properly, because law and order wasn't really a thing. So of course, extrajudicial means of settling disputes became a lot more popular as the politics of the time began to break down in the lead up to and the wake and after the wake of the Revolutionary War, which is of course when Hamilton lived. Plus, many of the colonists had been educated in England, and in England, in the aristocracy, again, duels were part of the education as a means of settling disputes, so they brought that education with them to the United States. On top of that, you have colonists who, like Alexander Hamilton, were kind of a rags to riches story, who didn't hold any sort of elite status, who then found themselves kind of thrust into positions of power due to their positions within military ranks in the Revolutionary War. So in this new republic, they had newfound status, and so dueling became a way to kind of assert your status and your gentlemanliness and your position within the aristocracy in the new republic, which again you see here in Hamilton. I mean, he came from nothing and he's establishing himself as this gentleman by agreeing to this duel. And in early America, because the political parties of the time had not been firmly established yet, I mean, the Republic was so new, much about politics was very firmly based on a politician's personality and not on a political party. Whereas today, people often will, vote along a party line, irrespective of who the politician is. Back then, it was very based on each individual politician. So duels were seen as a way for politicians to show that they valued their morals and their convictions more than they valued their life. And people were impressed by that, I guess. Okay, look, I know that I've been going on about duel law for a really long time, but I don't know, I just find this stuff fascinating. I think it's because it's like the most stark example of toxic masculinity at like the formation of our country that I've ever seen, and it's just, wow. This public custom that made duels popular lasted well into the 1800s. By the end of that century, however, it had really fallen out of fashion. And really, the laws that were passed to try to ban duels weren't really the impetus behind why it fell out of fashion. But this duel between Hamilton and Burr actually was one of the things that started the ball rolling on making duels less popular in American culture, especially in the North. There was a huge backlash in the North after the Hamilton-Burr duel, and in fact, New York decided to actually enforce its anti-dueling law. Again, like I said, a lot of states, if not all states, had passed anti-dueling laws, but they were never enforced. After the Hamilton-Burr duel, New York decided to actually enforce their law against both Aaron Burr and the representatives that participated in the duel between Hamilton and Burr. The representatives who participated lost their voting rights, and Burr fled New York and New Jersey, and his political career was pretty much donezo after this. So this Hamilton-Burr duel, coupled with the growth and popularity of partisan identification, meaning people were identifying with parties and voting along party lines more than they were identifying with people and specific politicians, meant that there was less incentive for especially politicians to compete in these duels. Additionally, the growth of the kind of commercial middle class and this kind of bootstrapping American mentality meant that aristocratic, antiquated traditions were kind of seen in a negative light, and people were less inclined to follow this kind of elitist tradition, and that included fighting in duels. So by the end of the 1800s, duels had fallen very much out of favor, and now, I mean, they wouldn't happen, and if they did, then it would definitely be a crime. And that's duel law, my friends, and that's Hamilton. What a fun show. I love this show. I mean, if I'm gonna give it a rating from a legal perspective, based on my legal knowledge, I would say, 10 out of 10. I very much enjoyed it, and a lot of the legal aspects of this, that I looked into at least, were quite accurate. So, Hamilton, 10 out of 10. Lawyer approved. Thanks for joining me today on this Lawyer Reacts video. If you'd like to see more of these, please comment below. Let me know what movies you would like me to watch, or shows. What's your favorite Law & Order episode? I'll watch that. I don't care. Comment below. I'd love to hear from you. Hit that subscribe button if you want to see more, and give this video a like if you found it entertaining. Thanks so much for joining, and I'll see you next time. Bye!